The recording has started.
Good morning, everyone. We're going to go ahead and get started with our subcommittee on law enforcement as it pertains to House Bill 3000. And this is today's meeting is going to, which is July 29th, Friday, cover two areas. But before we go into the meeting overview, let's go ahead and do the roll call and cross the T's and dot the I's. So for those who are participating today, please acknowledge your presence and whether you're here by video or by phone. Thank you.
Senator Podolsky.
I'm here by video.
Rep. Morgan. Sergeant Bechtel.
Sergeant Bechtel here by video.
Rob Bovet. Not here yet. Josh Eastman.
Here by video.
Heidi Ferguson.
Here by video.
Jake Johnstone.
Present by video.
I know Aaron Seiler for Bully could not make it. Kurt Miller.
Present by video.
Courtney Moran.
Courtney Moran, present by video.
Sheriff Stickler.
Present by video.
Amanda Swanson.
Present. My video isn't working today, but I am here.
Thank you. Scott Binkles.
I am present by video.
Everybody.
All right, thank you. So on today's agenda, we have two items that we will be talking about. The first one that's listed is the warrant discussion that is going to be led by Rob Bovet. Rob's not with us currently. Our second item is seizure and forfeiture that Sheriff Stickler is going to be giving us a presentation. And as the chair of the discussion, since Rob has not been able to join us to get us going, why don't we go ahead and just flip the agenda and have the first item be the seizure and forfeiture. So Sheriff, if that's okay with you, we'll go ahead and get you started, or let you get started with your presentation.
Yeah, so as far as formal presentation, I have a video that I wanted to share, but opening the discussion for, I guess, seizure and forfeiture. One thing that we have come across in our county, and I know each county might have a little bit different perspective, is the inability to kind of destroy or eradicate the hoop houses associated with these illegal marijuana grows. Now, I know in counties, Josephine County is able to do that. Their district attorney and their attorneys and the judges are willing to sign off on the fire hazard and whatnot. But in our county, there's a different interpretation. And I think we find that in many areas of the state where different DAs or different attorneys or different judges may have a slightly different interpretation of the law. And that's nothing unusual. But our attorneys and the DA feel we need to actually go through a process of seizing and then through a due process for these hoop houses. And that is really problematic and unrealistic because, as I'll show you in this video, some of these sites are extremely large and they're constructed in a manner that it really, you would have to dismantle. You would spend hours and hours and hours probably per hoop house, depending on the amount of labor force you had out there, but then storing it is unrealistic. Now, these hoop houses, in many cases, what we dealt with last year, were constructed, in my professional opinion, for the mere profit for the organizations growing marijuana. So they use what's called light deprivation to increase the cycles of the plant during the season. So instead of maybe a normal one cycle of growth, you may get two, they may get three. And Sergeant Bechtel, please jump in if you have any other information, because I'm really talking about information that comes from my team. I'm not on the ground day to day. But so really these hoop houses are put up for a very specific purpose, and that is to increase the profit for these criminal organizations or these black market growers. And so what our team has found is that in some instances, we like yesterday, the greenhouse that was constructed was actually big enough and constructed in a manner that allowed us to make just a small cut to the front of the greenhouse, which was plastic, and then get a small tractor inside. But that's not the case on a lot of these grows. And then what our team has to do is go in by hand with, equipment such as a, weed eater or other types of brush cutters, and manually do it or pull it up by hand. And when you see the size of some of the grows on this video, you'll understand why you can only do so much work in a week, or in some of these cases, it might be 2 weeks, or in some cases, when I show you one grow, it was so big, we didn't really even know how to tackle it this past year. Now that grow is not active this year as of it yet, but the infrastructure is partially still there. And so really, I know that in Josephine County, the sheriff's office is able to really eradicate some of these sites very efficiently with heavy equipment. They kind of destroy it in hours where we might spend a day. And that's kind of what we're looking for, is some sort of a provision in statute that allows us, when we find things that are created specifically for the enhancement of criminal activity, such as these types of hoop houses, that we could put it in our warrant and allow statutorily for us to destroy those like we do the product, and not have necessarily some liability attached to that. And not saying that we want to act with impunity, and we're not asking to go out and destroy a $50,000 greenhouse because somebody grew 3 marijuana plants in it. That's not the goal of this. The goal is to eradicate these large black market sites where these hoop houses have gone up in a matter of weeks. And when we don't dismantle them, sometimes we find that the individuals who own the sites, who are running the sites, so to speak, they'll dismantle them and then take all the materials to a new site, or they'll wait for a few days and then just replant because they know we're no longer on the list and we've hit that one and now we have to come back. So there's a lot of reasons to do it, in my opinion. And again, not asking for, there not to be due process or to have a warrant or have a judge review the probable cause asking for the destruction. But I think there needs to be some reasonable language in our statute to provide a sense of liability of operating within the law when it comes to these types of organizations who construct these buildings for the mere fact of enhancing their criminal gain or their profits. So, Sergeant Bechtel, do you have any other information about hoop houses while we're here before I show the video?
Sure. I'll speak to them a little bit. In my experience, they're very easy to tell the difference between a hoop house made specifically for the illicit purpose and a greenhouse. We have to constantly articulate this in warrants. They're of hasty construction, made with the cheapest available materials. So you're going to find them using landscape border timbers as structural timber. You're going to find them using low quality 2x4s. They're built lower, and there's reasons for that. One, you've got to pull that black and white plastic over to get your light deprivation. If you're not familiar with how cannabis flowers, when it hits a 12-hour light, 12-hour dark cycle, it begins to flower. So what they're doing through the summer, trying to get multiple harvests through, is they're using light deprivation. They're pulling a white plastic on the outside, black plastic on the inside over it to give it darkness, artificial darkness, if you will. So that's also one of the key factors. And so you've got to have a short, squat greenhouse or hoop house to do that, so that you can actually physically pull this massive amount of plastic over. It usually takes us 5 or 6 guys, 3 on either side, to pull the plastic off. Again, they're short so that you can lift the sidewalls up and provide ventilation during the day. In 108-degree weather down there, you're going to fry all your plants unless you can get some air through there. These aren't the $50,000, $60,000, $100,000, $200,000 greenhouses with, 2-code electricity ran in them, fans for ventilation. You have to physically lift the plastic up. These greenhouses are made to not withstand any kind of Oregon winters. They're not structurally sound. While we don't destroy them as part of moving equipment through them or anything like that, we frequently have to cut ventilation in them. When I have an officer in a 90-degree day doing hard physical labor with the greenhouse effect, you know, it's just not safe. Oftentimes we can work for 15 to 20-minute spurts. We'll have up to 100 officers at some of these. We chop and leave plants that aren't budded because we just can't do anything but kill them. There's no measurable THC content in them. So we'll just chop them and leave them right there. Oftentimes we'll fold back the roof of the plastic to allow incoming rain, if we know it's going to rain, to help destroy there. So I guess that they're hasty construction, they're short, squat construction, they're structural instability, they're cheap materials. These are things that, to me, point to a greenhouse made specifically for the illicit marijuana production. Is that what you were looking for, Sheriff?
Yeah, thank you. I think that helped. And then the last thing I would just say is, you know, for efficiency and the health of our staff, you know, having not been on a site where they run them over in like Josephine County, so to speak, but it really is. I mean, when you look at some of the size of the grows that we had last year, of course, you know, tactics are slightly different this year, but we're still seeing where this equipment could make, it could really provide efficiencies to our staff long term. And I think it is healthier for our deputies, officers, and troopers that are having to go into these and not breathe in the chemicals and all the things, because it is concerning what we're finding in some of these places. Now I'll show you a little bit of video just to give you some reference of how Sergeant Bechtel described these and what they look like, and it's pretty obvious. I'm going to try to do this.
Sheriff, can I add one more thing?
Yeah, go ahead.
And just because it's newsworthy recently, and I believe Cave Junction, I heard about, I wasn't there, had a, strangely enough, migrating monarch butterflies are very attracted to these structures. And again, they don't have any permanent doors or anything. And I hear thousands of monarch butterflies were inside the greenhouses dying a couple weeks ago. We were at one in Lynn County last week where I saw dozens of what I believe to be monarch butterflies, not being a biologist, inside these. And that's something, you know, what I love about working in cannabis right now is I learn something new every time we go out. And this evidently is a really big problem that we're just discovering.
All right, thank you. And I think the other advantage, and I think I might have mentioned this, what you'll see is this year we have a substantial amount of debris, plastic, trash that is kind of free to like blow around our environment. And I think being able to clean these up with heavy equipment would reduce the impact on our environment here, at least in our county. And I'll show you. I hope I can do this right here. Are you all seeing the video pop up?
It partially came up.
Okay. Can you see it?
Yep.
Yep.
Okay. So I think that kind of just gave you a kind of a real brief overview of how large in scale some of these operations are, what they kind of look like with the plastic on, what's underneath. And those are all pretty much examples of what we call hoop houses that were designed merely for the purpose of, light deprivation, and in my opinion, furthering profit for these criminal organizations.
Sheriff, thanks for that presentation. Let me do this. Let me open it up for questions, and I'm going to be the first, because from my review and history on these operations, it's my understanding most of those are not, the land itself is not owned by the operators of those farms. They're going in and paying a landowner X amount of money to have access, just like anyone else would contract the land for. So do we have any feedback as to how the landowners are dealing with these issues? I mean, once they've entered into these contracts, they got their whatever amount of money for it, and then all of a sudden you have all this residual still on your property.
Yeah, so technically the landowner is responsible for this cleanup. And code enforcement facilitates that out of our county, and that can come with, starting to try to work with a property owner, but then eventually could come to, potential fines or other things. And not to mention if there's other hazards or environmental damage that maybe the EPA may be interested in, the landowner is responsible for that at the end of the day. But as far as it goes for us, the landowner would be responsible for the cleanup, but I think for us in destruction of these hoop houses, putting it into more of a bigger pile and consolidating it would certainly be a good start for these individuals to clean their property the rest of the way up.
Okay. Other questions or comments?
I guess I'm going to play both sides of the fence here. Maybe Mr. Eastman, you could tell us the justification, because I just don't I have a hard time getting around the constitutional issues without due process, and I'd like to understand maybe how that's articulated. I mean, I definitely see a reason for this. I'm just struggling to find the way for it.
So we used to, when we first started this, I had the same concerns in due process. And I think early last summer, maybe May-ish, our building official or the head code enforcement guy and the head Illinois Valley Fire District guy had gone out on some of these. And they ended up writing and begging, basically, because what we were seeing was like pieces of plywood with 37 electrical cords coming out of it. Because what we can't see in these aerial photos is that the inside of these are fans and lights that are strung together by orange, you know, the normal extension cord you have at your house. And then they're all mounted on a makeshift sort of, I don't know, breaker board, but it's really just a piece of plywood with surge protectors. There's chemicals, there's streams and runoff. So we actually have memos written from the Illinois Valley Fire Marshal, or I think that's his title, and our building official begging us and explaining like, hey, you can't leave this. This is a fire hazard. So we include that in each of ours as sort of a condition precedent. Like if we find this stuff, then we're seeking authorization. Like my training experience is these all have it because they almost all do. And then if we find this, we get neutral and detached magistrate's position or approval to destroy it, because we can't just leave it if it's a fire hazard. It's Sheriff Sick, we were just discussing in the beginning, is 110 yesterday, and you know, the stuff that we've had the last couple of years, that was sort of what led to our judges signing and saying that, kind of for the same reason, Sergeant Bechtel, we don't store all the marijuana because it has mold. So it's evidentiary value, and it has its primary purpose is the criminal activity. There isn't a privacy or property interest separate from the illegal grow. It's kind of how we have written it in there, and our judges, case by case, of course, but so.
Thank you. That absolutely makes sense. And I just want to beat a drum here. The Lynn County grow that I was at last week had so many power cords daisy chained. It was a maze, and they're all split in 3 ways at the end. And every one of the outlets was melted. These extension cords would run hundreds of yards, and just in dry brush around a forest. You know, that coupled with the transformers blowing on indoor marijuana grows, I need to alert everyone. We are very extremely lucky we haven't had a massive forest fire caused by one of these grows, indoor or outdoor, yet. It's just the stuff that we see is amazing. Clackamas County is been really great in declaring buildings unsafe, both indoors and outdoors, and getting them condemned. We're getting power pulled at the street on those, which is really helpful. But you know, there's a lot of counties that there's only one code compliance person.
Yeah. So I see Scott Winkles and Carolyn Moran have their hands up. Before we go to you two, I want to do more of a direct, and Josh, this is really probably for you. In the situation where you've got these very concerning situations that have been identified and documented by your county enforcement agents or your fire chief, has there been an approach of going immediately to the owner of the property and saying, you have this fire hazard, you shall, or you need to take care of it within X number of hours, days, whatever it is, or you will be, you know, written up for it? I'm just trying to find out if there's other catalysts that we need to be putting on the table to discuss.
So our code enforcement has no citation authority. I think we're the only county, and the commissioners recently passed it. and then it was repealed in the May election. So there's no civil financial incentives locally. Our county council was, initiating forfeiture of the land proceedings, and then as sort of a agreement to cease that case, clean it up, no more. And then there's an easement, or I don't remember, appertent. I don't remember the right term. I don't do property law, but basically they agree not to grow marijuana anymore in exchange for the county not forfeiting their property.
Okay.
But as far as civil incentives via financial, our county code doesn't have citation authority.
Okay, thank you. So we'll go with Scott and then follow up by Carolyn.
This question, thank you. Scott Winkles with the League of Oregon Cities. This question's for Sheriff Sickler and Sergeant Bechtel. In your experience, how often do the property owners have knowledge of what's going on their land? And I'm asking because we did a lien statute years ago. It was updated in the last session to address the issue of civil enforcement for violations of 470, the marijuana code. And I can put that language in the chat, but I'm just wondering how efficacious that tool has been.
I think for us, code enforcement does go out with most of our search warrants, and they will levy fines on these, on the property owners and the people who put up the structures. So there may be an incident where they're doing both. So they're finding the individuals responsible, if they can find them, for the construction of the greenhouses and the unpermitted electrical and all of the things, and then also levying a fine against like I said, the property owner. Now, due process for that does take a substantial amount of time. I mean, you're talking, so many days to a hearing and all the things that need to take place. And sometimes, depending on, what has occurred in the past, we've had instances where, the growers will maybe even have enough profit that they don't care, they'll pay the fine. Now, those fines have gotten steeper over time because our county has tried to react to the issues at hand and increase their capacity of code enforcement. And there are instances where liens may be placed, but I'm not 100% aware of where that has, all that has been completed through a due process piece at this point. We did put out a letter last year in our tax, with the tax bills, that really it went out to every property owner in the county and said, hey, look, here's an issue with illegal marijuana. Here's what we're seeing. Here's what could happen to you as a property owner, which could include civil penalties and or criminal penalties if they're found to be, complicit in the activity. So they're aware of it and they know, but that's a pretty rare occurrence. It's mainly more of a kind of I guess, turning a blind eye, not necessarily involved in the activity. And that has had a pretty significant deterrent effect, or at least putting the word out. And it gives us an opportunity to really say, did you get the letter? And did you still lease your property to these individuals? So that's been a big help. But as far as placing a lien on property, I don't know that we have anything that has gone that far yet. I can ask our code enforcement, maybe report back next meeting and see. That would be something I could take care of.
Thank
Courtney?
you.
Yeah, thank you so much. So Senator Brzezinski and Scott are kind of getting to where I was getting, but the video that you showed, Sheriff Sickler, were all those properties that search warrants were executed, or is that what you're seeing just kind of on a broad scale of folks that were growing illegally last year and then have left all of this material?
Yeah, I think there's a combination thereof. I don't have all the property addresses. I know some of those locations were so big, especially I think the last one that you saw, that we weren't able to get to that last year. And what is left is just what has happened organically. You see the infrastructure kind of still there. Our thought is that, if the opportunity arises, the individuals will come back and use that site again. But we don't know for sure.
And Is there anything in place for cleanup measures, or is that something that this subcommittee can be looking to?
Yeah, I think, for us, one is property owners are responsible for their land. And then there's a pretty significant cost associated and a labor issue with, as far as, where you're going to get the staffing and the resources to clean those if you did it at, say, a county level. So that's one thing that would need to be worked out. Again, I haven't seen firsthand what it looks like in Joe County when they do use heavy equipment, but I imagine, and from what I've heard, is it's probably put into kind of a nice, neat, big, huge pile, which makes the cleanup probably much more manageable for a property owner to then just get some dump trucks and equipment and then haul it out as appropriate. And so I know that would probably aid in the cleanup to have those piles versus what you saw in some of those videos, which is just a massive amount of work to try to dismantle without equipment.
All right. So before I ask another question, Rob, I know you're up to do another presentation. Can you give me about how much time you need so we will make certain we allocate that much for you? Rob, you with us? I see you're up on the board. All right, let me go ahead and ask the question. So, Josh, in your county, since you're actually utilizing this procedure to go ahead and taking stuff out, is there some discussion with the landowner and kind of getting their consent, I'm going to use, as to, let's say, bulldozing and moving everything into a location? I mean, I'm trying to figure how we can, I mean, to me, the landowner, he or she, or the corporation that owns that land, are the responsible people. And even though we have these health and fire issues that we need to deal with, I don't want to see hate to say a windfall, but where they've gotten paid X thousands of dollars to use this land, and they basically are not accountable for the actual cost for the cleanup. And I'm wondering if there's been some type of discussions with some of those operations and dealing with it.
So the majority of the time, the landowners, there's an insulated maybe my cynical view, but layers to try to distance themselves from the grow, or like Sheriff Sickler said, sort of looking the other way. So they're not, and a lot of them are out of state. We had actually tried to levy a yearly assessment for landowners who spend more than such time out of state to sort of encourage people to be involved with their properties more. The majority of the landowners aren't involved, or we haven't reached out, and their LLCs or shields or organizations. So we still have some homegrown where the landowner, homeowner, whatever, is responsible for the grow. And then we don't include it in any criminal, like any costs, because I'm pretty sure all of the individuals assisting us are volunteering. I'd have to confirm that with Sheriff Daniel, but I'm pretty sure they're all volunteers because this is such a widespread issue. And I thought we were going to discuss, and I think Sergeant Bechtel mentioned it, there's a cleanup statute for meth labs, or what we used to have. We're meth labs, and we could attribute that in a criminal case, or they're automatically on the hook for that, which we would try that, but so far we haven't gotten to the costs. And the landowners, most of them, it's so far removed, it's really hard to prove, or they say, oh, I thought it was hemp, and then we can't go from there. So,
and Senator, I would also add really quickly that even if a landowner were to say, hey, you have my permission to destruct or deconstruct these hoop houses, still the thing we're running into is it's not their hoop house, it's not their infrastructure, and they had a lease, regardless of how fraudulent the lease may have been. And so really what we have is this, property right for an individual is what we're talking about, is the due process piece of having to go through a forfeiture process to get rid of that. And where we're arguing here is that those hoop houses are strictly constructed for the furtherance of criminal activity. So they're part of the criminal act. And there's also some safety concerns. You know, there's chemicals used, there's other things that I don't know that any of those materials would be valuable to be reused for anything else. And so I guess the point being is that not everyone is comfortable with the current system to just run that over without a due process piece. And that's kind of what we're asking for in this to be reviewed, is if we can show that this is purely a part of the criminal act and it has no outside, really, it's not a car that was used to haul drugs, so to speak, where you can, that car can also have value in other things. This is merely a piece of the marijuana cultivation. And that's what we're trying to get at. But this is the sticky point with the statute and the current liability is that's a tough thing to overcome, as Sergeant Bechtel alluded to.
All right. Sergeant Bechtel, I know you just came in. I've got Jake in line to ask a question. So Jake, why don't you go ahead?
Yeah, thank you, Senator Przansky. And I just wanted to kind of piggyback off what was said there regarding the ethereal nature of responsible party that District Attorney Easton was referring to. Just for this group's knowledge, that's something that really hamstrings WRD when we're pursuing administrative enforcement in these processes. Whom is the responsible party? You know, trying to find that LLC and where it leads has been hugely problematic for us in trying to utilize our tools. So I was just piggybacking off that, not as much of a question as much of a statement.
Okay, thank you. Sergeant?
Yeah, just more of a comment wrapping this up. What we're trying to do is balance, you know, constitutional due process with the greater public good. You know, even in the best case scenario, even when we're as least invasive as we can be as law enforcement eradicating these grows, we cause or further already done environmental harm. There's, I call it anti-cop net. There is this white or orange lightweight plastic netting that's used to hold the plants up, and we fight with it. I can't walk anywhere near it without it getting wrapped around my ankles. It's really hard. But once we're done with that, we form these plastic tumbleweeds that, especially in the valley, will blow for miles into grazing land. I've heard of complaints from cattle ranchers that you know this lightweight plastic is going into their grazing fields. It might not be such a problem down in Southern Oregon, but you know, there is just no way to leave no trace for us. And you know, you throw that in there with the electrical hazards, the structural hazards, the fact that these really will not overwinter with plastic on them. In most cases, just a few inches of snow, some driving rain or wind, and they're going to blow to the next property. They're going to blow to public lands, and so it's balancing a property owner or a greenhouse owner's constitutional due process with harm to the state is really what we're trying to do here.
Yeah. So I want to make sure we leave enough time for Rob's presentation on our next topic. So unless there's another question or comment on the seizure and forfeiture that we've just gone through, I'm going to go ahead and shift. So I'll pause for a second to see if anyone else had any follow-up to this conversation. And what I'll say to kind of put a closure on it, we'll continue to look at this. I will probably be reaching out to Rob Bovet to get his thoughts as to what we might be able to do and to tinker with the existing statutes and at the same time ensuring due process. I think as most everyone on this call realized, you know, the voters some years back actually did require a nexus on asset forfeiture to criminal activity. And so we need to make certain we're respecting and staying within the bounds of what they did when they passed it. But it doesn't mean that we can't address and shouldn't address areas where we do know that the activity was explicitly for the criminality of what their acts were. So I think there's still a lot of room here that we can work within and just make certain that we get all the, I'm going to call them certified smart people around the table that do process law and asset forfeiture to make certain that we stay within that bounds. So with that, I appreciate that presentation. Let's go ahead and go to our warrant discussion. That's a continuation. Rob, are you ready to take it over?
I am, Senator. Can you hear me?
Yes, we can.
Great. At work, and I apologize, Senator. I'm over in Bend here with 100 county lawyers, which is not a problem, but they tend to use up all the bandwidth. So I can't be on screen because it uses too much bandwidth, and my colleagues will deny me that bandwidth. So I'm on my phone, so I apologize. But what you have crafted that was sent out is a two-section bill to deal with the search warrant issues that the chair felt we had consensus wrapped around. So I went ahead and crafted those up. Michael's going to show it to you on the screen because I can't. If you go to page 2, Michael, that's the first part. Subsection 5 is the addition. This is language that I created to essentially address the issue of large drug trafficking organizations with multiple sites in multiple counties, and having the ability of one circuit court judge in one of those counties to be able to issue warrants for all of the sites. And so that's my proposed language to address that issue. The second big change here would be on the last page in a separate section. If you go to there's the magic language. Basically, I just decided to craft something that would not define out what other persons that can be present are, but give examples. So as you can see, I've said other persons may include, but are not limited to, and these are all of the folks that I heard us talking about that we want to be clear in statute can be there with the law enforcement officers that are actually executing the search warrant, if it's safe. So I'm leaving the safety language in there, of course, and these are necessary folks for that particular search warrant. So it's a non-exclusive list, essentially, but this is kind of what I thought I heard over the past few meetings. So that's my drafter's explanation of those two sections. I'm happy to move forward and crafting additional sections or tweak these. Sounds like I'm going to be, the next thing I'm probably going to be crafting some stuff to address the issues you just talked about, Senator. So there's my summary of what I've done so far.
All right, well, thank you. Looks very nice. Let me open it up for comments from anyone in our meeting for today. I see, looks like Kirk Miller.
Thank you, Chair. I think the language in the first section is really good. It gets at the heart of the matter. What we were talking about last time. I know we're going in another committee, we're addressing other issues related to this particular warrant language, so it may also get tweaked later on when we're talking about warrants that are used throughout the state for DUIs and things like that. So the DUI panel is working on that as well. The second section, I think Rob hits pretty much everything that we were talking about related to marijuana side of it. I never really love listing a bunch of people in there because sometimes, even though you say but not limited to, it kind of gets inferred as limited to those. But I can't, the only other people I can think of that would be necessary for successful execution of any warrant, not just marijuana warrants, would be medical personnel. So I think we should just add one more line for medical personnel, and that means like when we're talking about blood draw search warrants and things like that, that we would need to get nurses or phlebotomists or other certified people in there to take them. And unless the officers can think of other people we're missing, that's all I can come up with that's not included in that list.
You know, I think
I'm happy. Go ahead.
Oh, I was just going to say is if there's decisions to move forward with the destruction of these hoop houses in some way through statutory language, probably some caveat for equipment operators would be helpful, but I don't know if that would just fall under or other, you know.
And just to briefly comment on that, Sheriff, my thoughts on the cleanup side of it, and I know Senator Brzezinski was already talking about that, is that Rob probably knows this a lot better from the heydays, the 90s meth cleanup, that we just dovetail it into the 475 section that already deals with illegal drug cleanup for meth labs. And I think if you just tweak the language inside there, it'll have all the protections already built in, and the liens on property owners and everything else. But that's for another day. And so I don't think we necessarily need that on the successful execution of the warrant, because that would be more of like a cleanup issue.
And I was just going to add this, Rob, again. I agree with both things that Kurt just said and the sheriff's. Happy to add the emergency service workers. I already did have fire and rescue, but yeah, I should have plugged in emergency folks. That's an easy one to change. And I love Kurt's suggestion to essentially adjust the meth lab cleanup statutes. I love essentially not having to reinvent a wheel I've already invented before and forgot about 30 years ago. So let's make that workable.
And Rob, just to be clear, I'm sorry, Senator, if you were going to jump in. Rob, not just emergency medical personnel, it's not the people at the scene. Sometimes, we need to get a hospital or some other person that's a phlebotomist to deal with blood draws. So I would just use it as a broad medical personnel.
Exactly. Yeah. Got it. I'll just add an I, and I'll get you a third draft to look at.
Okay. Other comments? All right. Let me broach another subject within this. And Rob, you've not been advised of this. And Kathleen is here with the Oregon Judicial Department. And I'm going to say, before I say what I say, nothing has been signed off by the Chief Justice to go forward with this concept. But with that said, Michael, can you go ahead and put up that work of Rob's and give me sub 3 on the bottom of page 1? So everyone can see that notwithstanding section sub 1.
Page 1, sub 1, is that right?
There it is.
All right.
Section 1, sub 3. Just down a little bit. Yeah.
The
right
pro
there.
tem judge section. Yeah.
Yes. So this is just came up. This is just a thought right now. It is not something per se moving forward, but since we are looking at these modifications to the statute, and this would be one that could be modified. You can see the way this is written. It seems like the authority for these type of warrants to be acted on are limited to not only the circuit court judge that's active, but the judge pro tem. The question is, if we see more use of senior judges, judges that are on the plan B, that are not active on the bench, that are not pro tems, this subsection appears to limit or prohibit them from being able to make a decision on a warrant application. So I just want to throw that out there. Not sure we're going to go there, but what we may be seeing is a modification in that subsection to ensure that if we have more use of senior judges, that they have that authority that may be prohibited under this subsection.
Now, would you like me to craft that up, Senator, or just hold and wait until I get direction?
Why don't we hold on that for now, because I don't want to get too far out in front. The Chief Justice staff has brought this to my attention. I just wanted us, for full disclosure and transparency, say, hey, here's another area we may be looking at. And this is, the reason why we have these work groups or task forces is to have individuals with different perspectives bring it to the table. So I wanted to just put that on the table. And then that everyone here can think about it. And then when we do discuss it in greater detail, we can determine, if there's any hesitation or reasons why we may not want to do that. I mean, from my perspective, it seems like a senior judge, he or she has, the experience, because they're just basically transitioning from being an active full-time judge into retirement, should be able to do most anything that they were able to do as a sitting active judge, with the understanding that either the Chief Justice or the presiding judge of that circuit could in fact limit what their senior judges do. I don't want to take away that quote unquote local control and oversight, but it does seem like, and we're going to try to get some historical perspective as to why this particular statute was written the way it was, as to addressing pro tem judges, but not senior judges. And it could be as much as there's not much thought about senior judges versus an active judge, and maybe many thought that they would still be included. But that's just another piece for us to have on the table. comments and questions to that or anything else from Rob's presentation? And I see, looks like Sergeant Bechtel, looks like you're up.
Thank you, Chair Przanski. First of all, I want to thank Rob for writing that. I think I kind of brought these issues up, and it gets right to the heart of them. Except for one thing, and I don't think it's a legislative fix. It's the two-prong part of the multi-jurisdictional cases, the prosecution. That's really our hang up once we have the warrant is who takes the conspiracy, which county does it go to? I don't know if there's an opportunity for a special prosecutor through DOJ, but there's just resistance, and maybe Mr. Eastman can speak to this a little bit, to prosecute. Well, they can't prosecute anything out of county, but to reach into other counties and bring those criminals back to one county to prosecute, maybe for a racketeering or a conspiracy charge.
Right. Other thoughts, comments? All right,
Senator.
well, go ahead.
Sorry, I just had a quick comment. It's not, first off, Rob, great job. Thanks for taking the Scrivener's pen to page. And I just had a quick flag on subsection 5 and 133.545. Just a thought and a comment. I think I agree with Kurt. It does strike it. Based upon what I reviewed of the recording from the last meeting, it seems to strike at the intent of what this group is looking to do. I just wanted to kind of flag that I think some of the comments were related to RICO type cases. And so I didn't know, and I just was reaching out, Rob, just out of curiosity, if the interrelated criminal conduct kind of mimics that RICO language in the statute, just because there's a lot of case law and interpretation of kind of that piece. And so I just thought I'd flag it, not trying to draw one way or the other.
I actually thought of that and intentionally didn't craft it that way. We do have a state RICO statute that's very limited use, but really that statute lists out predicate offenses, and predicate offenses, you have to have multiple predicate offenses to create a RICO offense. I wasn't trying to be that narrow and circumscribing, because it could very well be we could have a case that really isn't calling for RICO. And so I tried to avoid that direct connection, but if people feel like that's a better connection, I certainly can craft around that. It would just look different.
All right, well, I think we shouldn't, I don't want to overtax you, Rob, as to making a lot of modifications on the drafts. I think these are points that we've now documented, and as we get further through this process, then we can start parsing what would or wouldn't be best and adequate in the amendments to this statute. So thanks for flagging all of that, and we'll figure out what the best terminology is. And this is something that maybe, Kurt, you can also weigh in from your perspective from DOJ as one of the attorneys as to, what would be the best language or more inclusive if we think we need more than what we got. So that's something for y'all to work through.
Senator, can I jump in for a second?
Sure.
One of the other things I was considering, I'm helping out on that other panel as well, but I do think it would be helpful in this panel that we consider it. When we're talking about warrants, and I know there's a lot of issues in the rural counties about how do we even get a hold to judges for addendum warrants, follow-up warrants on the first one, and then how do we serve those? I mean, I was chatting with some of the officers in Curry County, and they're like, at one point in time, there's only one officer in the entire county on duty in the middle of the night. And so there's just no ability for them to even print a warrant to serve it. So I was thinking that that would be helpful if we at least discuss another way to fix some of these follow-up issues, is that our statutes require service basically of a paper copy of a warrant. So if we just add a simple tweak to those statutes as well to allow for an oral recitation of the warrant, that the judge grants, and then a follow-up with a paper warrant at a reasonable time, that would be one other way for us to kind of give some help for the officers to have to kind of chase these paper trails, so to speak.
All right, I'm gonna.
But that
let,
should be a topic for another day. Sorry.
No, it will be. I mean, I've got I guess, somewhat of a response as to crossing the T's and dotting the I's and making certain that if you had something that was orally, I mean, if it's not somehow recorded, I see defense and others coming to challenge. So you want to make certain that, it's got to be documented somehow. Now, whether it's got to be in writing versus some other means of preservation, I think that's for us to consider. Sergeant Bechtel.
Just to set the scope of this, what Kurt was just saying, we've lost the mobile vehicle exception recently, so the need for immediate warrants is beyond this cannabis thing, and so I just keep that in mind as we go forward.
Okay. Well, I'm assuming, Kurt, your shop is probably working on that issue, that maybe this would be brought in and inclusive to deal with this as well.
Absolutely. And I think what we're looking at more so is that it would be an electronic warrant, right? We would have an actual documented PDF warrant. We just couldn't print it out and serve it upon the person. So it would be read to them, maybe even showed to them in an electronic format, and then just followed up later on with paper. And like I said, our statutes are predicated on the days before we had a lot of electronic warrants. And so I think that's just something that if it was a joint thing coming out of two different committees, it might have a little bit more to show that this is something that could help throughout the state in multiple areas rather than just one.
Okay.
But as far as the resources that we were talking about earlier, that's always something that people can talk more about. Resource prosecutors, right? We house quite a few different resource prosecutors, and so that would be something that all of the different groups would need to talk about if we could have a marijuana resource prosecutor. But that's my last comment on there.
Okay. Thank you. All right. Any other comments, questions? So Michael and Tisha, what else do we want to do in dotting the I's and crossing the T's for today? You're muted.
Of course. We don't have any other items on the agenda today that we need to cover. So it's just if you wanted to, introduce another topic or go back to some of the topics we've already discussed to go into more detail on some of those.
All right. Well, folks, I'm going to say this. It looks like we're, I'm going to say, on schedule ahead of time. You could have more time to yourself, so we could have a little bit more discussion on whatever we've already have discussed, or want to, maybe put even a marker on something else for the future. So, and if not, then, we could let everyone have an extra 20, 25 minutes in their day.
So our next meeting is August 22nd. If anybody has anything that they want to circulate to the group and you have any trouble with it, you can just send it to me and I can circulate to the group for you. Thank you.
All right, and I'm going to just do this because I'm not sure. Michael, you are making your transition somewhat in the near future, and I apologize for putting you on the spot right this moment, but are you going to stay in the El Pro world on a telecommunicating and will be with us before at our next meeting?
Yes. So just for those who don't know, my wife got a job in Seattle, and so we're moving up to that area here actually next week. I am planning to still work remotely for El Pro as we've been doing recently with the pandemic. So no immediate changes, but I'll slowly be transitioning out of El Pro in the coming months probably. But we'll be around for this committee at least in the near future.
All right. Yeah, I just want to make sure we have an appropriate send off before you take off. So we'll reserve that for another day. All right, folks, thank you very, very much. As everyone knows, it's very warm in the state right now. Stay cool, hydrated, and be safe out there, and take care of your friends and neighbors. Everyone be well and enjoy your weekend.
Thank you.